All right, let's talk business. Every single company, whether it's a tiny startup hustling out of a garage or a huge corporation on the stock exchange, has to play by a certain set of rules. And in South Africa, that rulebook is the Companies Act. So today, we're going to unpack exactly what that means for you. So who protects you when a company makes a big decision? I mean, really think about that for a second. Let's say you've put your hard-earned money into a company, you're an investor, and they're about to do something, well, something you think is a terrible idea. Or maybe you're an employee and the company hits a rough patch. Who's looking out for you? Who's got your back? Well, in South Africa, the answer is this really powerful piece of law, the Companies Act of 2008. Now, this isn't just some dusty old update. It came into effect on May 1st, 2011, and it didn't just tweak the old law from way back in 1973. Nope, it completely ripped it up and started fresh, creating a whole new blueprint for how business works in the modern world. Okay, let's dig into that. Why the massive change? What was the whole point of this new rulebook? Let's get into the why behind the act. First off, and this is a big one, it's all about encouraging entrepreneurship. The idea was to really fire up the economy by making it way simpler and more flexible to start and run a company. Cutting through the red tape so that great new ideas can actually get off the ground and thrive. And it's not just about making things easier. The Act also pushes for some seriously high standards of corporate governance, basically promoting transparency. It's built on this idea that businesses are, well, they're more than just profit machines, right? They're a huge part of the country's social and economic fabric. And with that kind of influence comes a big responsibility to be open and honest. And then there's this critical piece of the puzzle, balancing rights and obligations. The Act really tries to find that sweet spot, creating a fair balance between what shareholders, the owners, are entitled to and what the directors, the people actually running the show, are responsible for. So let's dive into the shareholder's voice. How does this act actually empower the company's owners? This is where things get really interesting because the law gives shareholders some serious teeth. First, let's talk about a key concept, the proxy. Basically, you don't have to physically show up to a meeting to make your voice heard. The Act gives you the right to appoint someone, a proxy, to go in your place. And this person can participate, speak up, and cast your vote for you. It's a super practical way to stay involved. But what if you're in a situation where you fundamentally disagree with a major company decision? What happens then? Is just voting against it enough? Well, the Act says no, you're not just stuck. This is where one of the most powerful shareholder rights comes into play, something called appraisal rights. So let's break down what your appraisal rights look like. Think of it as a clear, step-by-step process for when you, as a shareholder, just can't get on board with a big change. First, you have to give a written notice saying you object before the vote even happens. Then, step 2, you actually have to vote against it. After that, you can formally demand that the company buys back your shares at a fair value. The company then has to make you an offer. And here's the kicker. If you think their offer is a lowball or if they don't even make one, you can take them to court to figure out what a truly fair price is. It's an incredible safety net for your investment. All right, so shareholders are covered. But they're not the only ones with protected rights. The Act also looks out for the folks inside what you could call the engine room of the company. We're talking about auditors and employees. And this slide really highlights two critical roles and their key rights. On one hand, you've got the auditors, who are like the financial watchdogs. They have the right to get into all the accounting records, the books, the documents, everything, at any time. No questions asked. Then, on the other hand, you have the employees, the human capital, and their big right here, they get to be consulted when a business rescue plan is being developed. So you have financial oversight and human impact, both protected. Okay, but what happens when business isn't booming? What about when a company finds itself in real financial distress? Under the old system, that often meant a quick and messy end. But the Act provides a much more structured path back from the brink. Yeah, instead of just letting a company collapse, the Act provides for the efficient rescue of financially distressed companies. It's a formal process called business rescue. The whole point is to give the company some breathing room, a chance to restructure and hopefully recover. It's about trying to save the business, preserve jobs, and protect value rather than just shutting everything down. Now, what's really crucial about business rescue is that it's a balancing act. It's not just about saving the shareholders or paying back the biggest creditor. The business rescue practitioner has to juggle the interests of everyone involved. You've got the employees, the creditors the company owes money to, the shareholders, and any other affected parties. The goal is to find a solution that's as fair as possible for every single stakeholder.
So it's great to know you have all these rights, right? But what good are they if you can't actually do anything with them? So how do you enforce your rights? How do you make your voice heard and actually get results?
Well, the good news is the Act gives you several different pathways to get a resolution. It's not just sue them in the high court, which can be daunting. You've got options like alternative dispute resolution. You can apply to the company's tribunal. You can file a complaint with the CIPC, that's the Companies and Intellectual Property Commission, or, depending on the issue, even the Takeover Regulations Panel. It's designed to be a much more accessible system. And this quote from the Act really says it all. A person may seek to address an alleged contravention or to enforce any provision. What that means is the law isn't just a passive rulebook sitting on a shelf. It's an active invitation. It's literally telling you to use these tools to step up and enforce your rights. So here's the bottom line. A company has rights, and it has obligations, but who ensures it has a conscience? The Companies Act is an incredibly powerful rulebook. It's designed to help businesses grow while also making sure they play fair. But a law can't give a company a conscience. It can only provide the framework. At the end of the day, it's up to the people, the shareholders, the employees, the directors, to use that framework to build companies that aren't just profitable, but are also responsible. And that really is the whole point.